Alex here with part 151 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my access sprung rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We go into a motion for reconsideration that I filed in the Supreme Court. This is a case that's long since been dead. It's the appeal that was dismissed because it couldn't pay the filing fee. It's specifically the appeal over the child support imputation of income way back. I think the last video on this topic, or on this portion of litigation, was part 133. This has nothing to do with the new appeal. That is an appeal that I'm going to win. But this old appeal has a pending motion for reconsideration that I filed. I think I remember the basis for the filing, but there's no need for me to speculate. We can actually just go straight into what I have filed. Here we have my motion for reconsideration. It is very short and sweet. I am identifying myself at the court as the appellant. I'm indicating that I'm appearing in proper person and that I'm moving for reconsideration of the dismissal order. The reason being that the Chief Justice acted alone in dismissing the appeal, which is a violation of the rules of appellate procedure. Rule number 27, subsection C1, that forbids a justice of the Supreme Court from dismissing or otherwise determining an appeal. I am identifying this as a domestic relations matter involving children, and it was dismissed for lack of sufficient funds to pay the filing fee and bond, and that it would be appropriate for a full panel of justices to reconsider the dismissal. I don't regret this filing because it's actually meritorious. There is a local rule in the rules of appellate procedure that says only panels can dismiss cases in the appellate courts. And my motion is very short and sweet. It just says, hey, you guys didn't follow your own rules. So I bring this to their attention, and they do end up following their own rule. They just end up dismissing the case. All three justices just agree with the Chief Justice, which is sad. But I guess, I've talked about this before back in part 133, so I'm not going to repeat myself. This is a very disillusioning appeal. I don't know what else to say, especially given it was connected to my son's surgery. He needed the surgery more than he needed the appeal, and it's too bad that they make you choose between the two. I feel like they should know better than to do that, but I'm going to just move on. We have Rule 5 Certificate of Service indicating that I served this motion upon my ex. And here we have the order denying motion for reconsideration, and this time a full panel of justices has signed it. We have Justice Hardesty, Justice Douglas, and Justice Cherry, and they have stated that no good cause appearing, the motion is denied. The provisions do not apply because the matter was dismissed by the court sua sponte and not in response to a motion. What? Oh man, so these three people, they probably didn't even read it. Okay, this makes more sense now. These three justices, for sure, did not read anything. All they did was look at this rule, and this rule 27C1, and they said this rule doesn't apply because the judge threw your case out without any kind of pending motion or anything. He just threw it out on his own, so this rule doesn't apply, and that's it. So these justices didn't look into the circumstances of why I couldn't afford to pay the filing fee. So the only justice who screwed up is Justice Mark Gibbons. He either didn't read anything, or he actually did read it and he didn't care. I'm leaning more, my opinion is that he cares very much. And so I'm leaning more in the direction that he just didn't read it, and that somebody else read it and he trusted their report on it, or that they just very quickly rubber stamp dismissed it. I don't think that he actually, given the facts and circumstances of the case, would want to throw it out. So more likely than not, some underling did that work for him, sent it up to him, and he just signed it without reading it. These three justices for sure didn't read anything. This here says that they only looked at the rule and they determined that the rule didn't apply, and that therefore, because that rule didn't apply, they were going to throw the case out. So these guys mean it when they say it. When they just check one thing, they only check that one thing. I am absolutely certain that these three justices would not have looked back at any of the circumstances of the appeal. They would have just looked to the rule, decided it didn't apply, thrown it out, and moved on. So yet another disappointing situation. I guess you can say at least they complied with their own rule in the sense that that's all they looked at. But in my opinion, that's just a big giant hole in the appellate process, especially with regards to appeals regarding kids, child custody, families, etc. And this is the remittitur, which is just a receipt. Think of it as a receipt. It goes back to the lower court and it lets the lower court know, hey, we're done here. You guys can take full control of this case back over. And so that's it. The remittitur is transmitted to the district court, letting them know that they once again have been vested with jurisdiction over the case. And then the next page here is just a clerk certificate. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney in this appeal at this point in time, so I incurred $0 in attorney fees. My ex didn't participate in the appeal, so she incurred $0 in attorney fees as well. As with my previous videos, if you have any questions, feel free to post them down in the comments below. Keep an eye out. Part 152 is coming, and it is going to premiere, so please keep an eye out. Watch the what is it called? The discussion board of the proper person. Watch the discussion board. It should be coming out Tuesday or Wednesday, at the latest I think Thursday, and we will be premiering the entire hearing over the course of the next 3 or 4 videos on this channel. I look forward to going through that with you guys. Yeah, already, as I mentioned, post anything down in the comments below if you have questions. I will see you guys next time.